Hello and welcome. You're watching Newscentre. I am Ashmit TejKumar. Now, the foreign investor community is in shock after the Supreme Court ruled that Tiger Global's $1.6 billion stake sale in Flipkart to Walmart is now taxable in India. The apex court held that Tiger Global cannot claim capital gains tax exemption under the India-Mauritius tax treaty. Remember, Tiger Global exited Flipkart in 2018, selling its stake to Walmart. Now, the investment was routed through a Mauritius-based entity, and the fund had claimed tax exemption under this treaty. However, the court ruled that the transaction structure amounted to treaty shopping and that tax avoidance. It said that the treaty benefits cannot be granted merely on the basis of a tax residency certificate. The court also noted that the India-Mauritius tax treaty was amended in 2016 to ensure that only genuine entities with real commercial substance can avail of these benefits. The ruling can and will have far-reaching implications for foreign investors, including private equity funds, venture capitalists who routed investments into India through Mauritius. Now, experts warn that this verdict may prompt the tax department to scrutinize similar transactions, potentially setting the stage for more litigation. All of this comes at a time when the startup funding has already slowed down. So what options does Tiger Global now have, and what does this ruling mean for the broader investor community? To help us unpack this judgment and the implications with this, is with us Sachit Jolly, Senior Advocate of the Delhi High Court, and SandeepJhunjh, Partner at Nangia Global. Gentlemen, thank you so much for joining us. Mr. Jolly, let me come to you first. For very long, for the last 20-odd years, there's been this understanding that there is some degree of protection under the India-Mauritius tax treaty. So whether that's the government circular of 2001, whether that's repeated judgments coming in from the Supreme Court, whether it's the amended DTAA, which had grandfathered, which had protected pre-2017 investments, can the investor community now afford for the Supreme Court to do a U-turn, to backtrack on a long-standing position which has given clarity to investors on how to go about investing in India?
Ashmit, I must honestly say that this judgment creates a lot of uncertainty. It is, you talked about grandfathering and the amendments to the treaty in 2016, which protected past investments. Even the GAR provisions which were brought in protected investments prior to 2017. This judgment seems to say that if the effects or the tax consequences of the investments come about after April 2017, the amendments to the treaty, GAR, all can be invoked to bring to naught the years of certainty which has prevailed on the Mauritius route, and which was also sought to be protected through the amendments of the treaty in 2016 and the amendments to the Act of 2017. I'm quite aghast that on one hand, the judgment records that the finance minister, while bringing in GAR or the general anti-avoidance rule, as well as other amendments, clarified that this will not affect past investments. But then the tax department goes and argues something to the contrary, and the Supreme Court accepts that. I'm actually at loss of words to even explain this to any investor on how does our tax administration and how do our courts function. It's quite amazing.
So a lot of questions that need unpacking. Let's try to go through that one by one. Mr. Jhunjhunwala, let me come to you. In terms of understanding what the implications are, firstly, tell us, is the tax department now emboldened? Can they now scrutinize all pre-2017 investments into India via Mauritius, whether that's PE, venture capital, FPI? Are they all vulnerable to taxman's scrutiny?
Yeah, so Ashmit, in short, yes, but I think it's also equally important for us to understand that if we look at the case of Tiger Global itself, there has been a lot of development in the international tax world, say between 2012 and 2018. So 2012 and 18, because the entire arrangement that we're talking about of Tiger Global making investments in Flipkart through their Mauritius structure was set up in sometime in 2011-12. And between then and 2018, I think there has been a change in the world order. A lot of developments in the international tax world. Say, for instance, we had GAR coming in. We had a lot of action plans being implemented on BEPS, etc. Now, what we are seeing now is the court clearly saying that this is not about disregarding the tax treaties, but maybe looking at it from a more deeper lens of commercial substance as well as the intention. So, therefore, I would rather believe that while the GAR as a tool to probably expand and scrutinize the structures may, probably increase, it's equally important for the investors to relook at their structures more from a substance as well as from an intent perspective. And if I think these two dual, substance as well as intent is cleared, I don't think GAR is going to be a problem for them. But it all depends on the facts.
It all depends on the facts. Mr. Jolly, let me come to you. Again, the same question that pre-2017 investors who've been looking at the India opportunity have been pumping in money via Mauritius. If they've made that investment pre-2017, is there cause for concern for them? And not just Mauritius, what if I've invested in India via a Singapore, via a Cyprus or a Cayman Islands? Am I vulnerable? Do I have reason for worry?
Well, absolutely, yes, Ashmit. I have a lot of reasons to worry. And I'll tell you two very far-reaching implications of this judgment. One is that, even if I invested prior to 1/4/2017, which was the cutoff date, the judgment seems to say that, in fact, in one passage, it says, since the negotiations for sale started after 2017, which is in May 2018, therefore, we can look at even the structure which was created prior to 2017. So, then what is grandfathered? Nothing is grandfathered according to this judgment. So everybody and anybody who made investments prior to 1/4/2017 is today in jeopardy. Secondly, and more fundamentally, it seems to suggest that the indirect transfer which happened in this case, where is a Mauritius company selling the shares of a Singapore company, is not at all protected by the Mauritius Treaty. It says that the investments must directly be held by the Mauritius entity in the Indian company. If they are held through a structure, then there is no exemption available. So that to my mind is quite baffling, because whether I am selling as a Mauritian investor, whether I am selling shares of an Indian company or whether I am selling shares of a Singapore company, I am only selling shares. Article 13.4 of the India-Mauritius Treaty protects transfer of shares. So therefore, really this artificial distinction which the revenue drew and which the court accepted is mind-boggling, and it's going to have large implications, not just for this taxpayer, but I think everybody around.
That, in fact, has been a criticism that many experts have put across, that there was this understanding between India and Mauritius on grandfathering pre-27, on protecting, on shielding pre-2017 investments. Mr. Jhunjhunwala, let me come to you on that. That the question many are raising, like Mr. Jolly, is that, look, the treaty itself said that pre-2017 investments will be protected. For the Supreme Court to now walk back on that agreement between two individual countries, does that then lead to more confusion, more uncertainty in the minds of investors?
Absolutely. There was an absolute immunity given on the 2017 grandfathering. It was never subject to GAR, no conditions attached. Now, with this, where they are even talking about the structure itself to be an impermissible tax arrangement, they're not even talking about giving a treaty benefit to a income which is coming out of an investment, but they are trying to overall say that this structure itself is impermissible, and therefore the provisions of GAR should apply, is, in some sense going back from what was, probably agreed at the time of giving this absolute immunity from grandfathering way back in 2017.
Sure. Again, laboring on that same point, Mr. Jolly, let me come to you. One aspect that, in fact, the judgment dwells on is that the sovereign power to levy tax needs to be retained. It should not be frittered away. It should be protected, especially in times of geopolitical uncertainty. That's the message that the court is sending. But speaking of the sovereign, these were two sovereign countries that negotiated and agreed upon this deal. But the Supreme Court is asking the taxman to go back on something that was agreed between two governments.
Ashmit, I'll tell you, this is a bogey which is being played by the tax administration for long. And let me address this because this is an absolute, I hate to say, for better words, it's a rubbish argument for the reason that the Act of Income Tax Act was promulgated by the Parliament. Circular number 789 was issued by the CBDT, which is an instrument of the state of India. The treaty was negotiated by the executive. Now, who's undermining whose sovereignty? Are you saying the treaty undermines the sovereignty, the circular undermines the sovereignty, or the act of parliament undermines the sovereignty? In each of the cases, the blame lies with the government. How is the taxpayer being blamed for this so-called lack of certainty or sovereignty? I mean, it's mind-boggling. Today, India goes and negotiates its tax treaty with Mauritius, UK, US, and says, you tax X amount, I tax Y amount. I have given up that sovereignty by choice. Now, how can then you go to a court and say, look, this, if you don't let me tax it, my sovereignty is lost, but you've given up that right. You shouldn't have negotiated that treaty. So, I mean, for lack of better words, I think this is all rubbish. It's a false bogey. This whole tax nationalism needs to go. I mean, otherwise, no money will come into India.
Sure. Let me come across to you, Mr. Jhunjhunwala. Today, on January 16th, we celebrate the 10th anniversary of India's Startup India mission. At the time when there is a funding winter, when we look at the startup community, how much concern will this cause in the mind of PE, venture capital investors who are looking at the India opportunity? Will they now perhaps start recalculating, recomputing their ROIs and then be circumspect in whether or not they want to be a part of this India story?
Yeah, so Ashmit, I think we are actually looking at a lot of exits as well in 2016 based on some of the pipeline available on the public domain. So I think this definitely is going to create a lot of unrest among the non-resident investor community because the old playbook is completely dismantled by the ruling, and therefore in some sense wherever investors would have set their structures and forgotten that, okay, they may probably look at the capital gains implications only at the time of exit without even probably looking at the substance and the intention requirements in the interim period. I think that's going to create a lot of unrest among the non-resident community now who are probably looking at an exit in the near future, because this ruling in some sense creates a precedence that some of their structures itself could be questioned from a GAA perspective. So having said that, I think one of the points that is also to be looked at is, tax harmonization. We are living in a coordinated world where probably India needs capital, foreign capital in the race to the top. Now, definitely tax sovereignty in itself could mean that there's an international isolation. So when we are talking about tax sovereignty, there's an equal and critical importance that needs to be given to the concept of tax harmonization. We kept talking about US levying tariffs, which was unilateral. I mean, if we keep talking about tax sovereignty in isolation, the entire world trade is going to collapse. So this definitely is going to create a lot of unrest amongst the foreign investors.
Sure. We're running out of time, Mr. Jolly. I'll come to you for one quick comment. What does the way forward look like? We've seen the Vodafone judgment, which was given by a 3-judge bench. This Tiger Global judgment has been given by a 2-judge bench. How do we look at it? Is there a need for a larger bench? Is that a case that the lawyers of Tiger Global now need to make to ask for a larger bench, clarity from a larger bench?
Well, Tiger Global was being led by 2 stalwarts. I think they'll decide whether to approach a larger bench. But according to me, I think, Ashmit, I'll tell you something. If you see the question of law which the High Supreme Court formulates in para 11.1 and what it answers, according to me, it could not and it does not overrule Vodafone. Secondly, it does not and could not overrule Azadi Bachao. Therefore, according to me, both those judgments still stand. If I were to argue, I would say this judgment turns on its own facts and the question that was proposed before the Supreme Court. There are certain observations, yes, which are directly and inherently contradictory with the findings in Azadi Bachao as well as Vodafone. And if I were to argue, I would say that those judgments still stand good and I'm still protected. And this judgment in Tiger Global is an outlier. I, you know, in jurisprudence, in legal jurisprudence, a two-judge bench does not and cannot overrule another two-judge bench of Supreme Court or a three-judge bench. And therefore, as I would look at it, Tiger is an outlier and should be treated as such. It is not the
So
law of the
clearly,
land for all times to
these
come.
are these are the very points, the very questions that we'll all be deliberating, squabbling, and perhaps debating as the days and the weeks progress from here. But clearly, a substantial, a landmark ruling coming in from the apex court. Whether or not it gives clarity or whether it causes more uncertainty, of course, is up for debate. I'd like to thank both of our panelists for joining us, sharing their time and perspective. With that, it's time now for heading into a very short break. But on the other side, India and the EU are expected to ink a trade deal during the visit of top EU officials to India. Details when we come back. Welcome back to News Centre. Now, India and the EU are expected to ink a trade deal during the visit of European Commission President Ursula von der Leyen and other top EU officials to India. Now, sources tell CNBC-TV18 that there is every possibility of securing a good deal by January 27th. Abhimanyu Sharma is joining us now with more details. Abhimanyu.
Possibility of yet another big free trade agreement between India and a large economy seems bright. By the end of this month, India's largest trading partner, European Union, is already in talks with India for a free trade agreement. 20 out of 24 chapters have already been finalized. India's Commerce and Industry Minister Piyush Goyal has indicated that India has signed 7 FTAs since 2014, and the India-EU FTA would be the mother of all FTAs which have been signed till now. As far as talks between both the sides are concerned, they are continuing on a day-to-day basis in the virtual mode, and they are currently in the last and most arduous phase of negotiations. While sensitive agricultural issues are off the table due to sensitivities on both the sides, several other sectors would be opened up on a mutual basis for both Indian as well as European exporters, which are going to provide huge opportunities for a growth in trade. Commerce and Industry Minister Piyush Goyal also indicated that not a single EU state amongst the 27 members has opposed the FTA with India, and at different points of time, all member states in the past few months through several channels have supported an increase in overall trade partnership with India. It remains to be seen how early the FTA is going to be concluded and signed, even as India's leadership is slated to meet EU's leadership later this month in New Delhi. And before that, both the sides are trying to conclude talks and to ensure that there is a mutually beneficial deal on the table.
Well, now to the latest on the Sanjay Kapoor inheritance battle. Priya Kapoor has moved the Supreme Court seeking records related to the divorce between Sanjay Kapoor and Karisma Kapoor. She's seeking certified copies of the divorce settlement proceedings, which concluded in 2016. In her plea, Kapoor states that the details of the divorce terms are critical to ascertaining the entitlement of Karisma Kapoor and her children. The plea comes amidst an inheritance dispute initiated by Karisma Kapoor's children, which is currently pending before the Delhi High Court. And with that, it's a wrap on this edition of News Centre. More news and updates will continue right here.